This is Kelly J. McKibben. She is the Circuit Court Judge in the 18th Circuit, currently Brevard County Dependency Court Judge. So she's been doing that for how long?
Let's see, almost 2 years.
2 years. Judge McKibben has been a judge since the end of 2005, December 2005. She was appointed to the county court and then subsequently to the circuit court. I knew her way back when her first name was still Kelly, before she changed it to Judge. She was my supervisor. It was about 20 years ago, actually, that we first met. We were trial partners. And so she was chief legal counsel for the Department of Children and Families, was her last position before she took the bench. So she's been doing this for quite a while, and she's here today to give you all the perspective of the Guardian program from the bench. So I'm going to turn the microphone over to her.
All right, good afternoon once again. I know that some of you were here for the last session on substance abuse, so you already heard my introduction and my experience and background, that I did start as an attorney for the Department of Children and Families out of law school. And yes, Ms. Swartz was my trial partner, and we were known as the Dream Team. She obviously is still involved in child welfare and a huge child advocate, and I've always enjoyed working with Ms. Swartz, and we've become friends over the years as well. And of course now, since I am handling dependency cases, although she doesn't really appear in front of me, I have to be mindful of that. But we did have some great stories that we could share with you, but that's for another session. So let me just start with, first of all, are all of you in this room Guardian Ad Litem volunteers? Is there anyone that's not a volunteer? Okay, so a few staff members, yes. I see familiar faces in the back, and some attorneys, but most of you are volunteers for the Guardian Ad Litem program. Let me first start by saying thank you, thank you, thank you. Because without you all, I would not have as much information that I need every day to make the decisions that I make. And I know that I see some faces from Brevard County, and go Brevard. But obviously not all of you are in Brevard County. You're from other counties and circuits, some of you from Fort Pierce primarily, but I really do rely on the Guardian Ad Litem program and the volunteers to give me vital information on the cases every day. Now, what's important about the role that you all have is you all, as the Guardian Ad Litem, are parties to the case. Now, if you're new to the Guardian Ad Litem program, you might think, well, what does that mean? Well, as a party, you have the same level of footing and same level of involvement in the case as does the parent, as does the Department of Children and Families, as does the child. You all are parties. So you can ask for relief from the court, you can file motions through your attorneys, of course, but you all have a significant role to play. And what I think makes you all unique is that you are independent from any other party. In other words, parents have their own perspective. They don't always agree, obviously, with the department and the fact that their children have been removed. They don't like my decisions very frequently as the judge. But you all don't have an affiliation with the parents. You don't have an affiliation with the department. You are there strictly to act and present and report on the best interests of the child. And so that's what makes you all unique. And again, without the number of volunteers that we have that are committed to taking the time to research the case, to talk to the child, to talk to the providers, or whatever information that you all find to be pertinent and necessary to report to the court, I wouldn't be able to do my job as effectively. Now, again, I'm coming from Brevard County and I'm giving you my perspective. Other judges may have a slightly different opinion overall, but you all, in my mind, are a critical piece to ensuring that children's needs are being met and that there is a voice that is heard. So let me say again, thank you, thank you, thank you. So let's give you all a round of applause. So how many of you have been a volunteer for, let's say, more than a year? Wow. You all are just getting your education credits, right? You just had to mandatorily be here, is that right? All right, how many of you have been a guardian ad litem for more than 3 years? Okay, how about more than 5 years? A couple of you in that category. How about more than 7 years?
Whoa.
How about more than 10 years? Okay, where are we at? 7? Ma'am, how long have you been a volunteer?
Me?
Yes.
8 years.
8 years. How about you? 8 years. Do we have anyone more than 8 years? All right, you all win the prizes. I don't know what prizes we have. So we have some very experienced volunteers in this room. So I may be telling you something that you already know, but I'm here to answer some questions. Anything that you want to know that I can hopefully offer some insight in, and Ms. Swartz and I are going to also present on some issues and questions that might be pertinent to help you all out as you continue in your role as volunteer. I also recognize that, when you sign up as a volunteer for this program, this is not a situation where you're going to be committed and involved for 3 months and then the case is over. It doesn't happen. Sometimes the cases will go well beyond the 12 months to permanency, and you all are still there every day. And that's the other thing that's unique about the Guardian ad litem program that I appreciate, that many times you all are the only constant in that child's life. The attorneys switch out, the case managers switch out, but generally speaking, you all as volunteers are there for every or most every hearing, and you're there for that child. So I do appreciate that factor as well. So a couple of things that I've observed about the Guardian ad litem program, because I've played different roles, obviously as the department attorney, being a party to a case prior to becoming a county judge and now circuit judge, and now from the perspective of having to listen to the input that you all have and then assimilate that with everyone else's input. And obviously dependency cases are a very different type of case. When you're dealing with a criminal case, you have the state, the prosecution, and then you have the criminal defendant. You have the two parties generally. Sometimes there's a co-defendant, but you only have the two parties and you're going forward and the case gets resolved one way or the other. But in a dependency case, as you all know, we have parents, we have the department, we have the Guardian ad litem program, we have an attorney ad litem sometimes. So it's always interesting when you have direct examination, cross-examination, 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 and on it goes. So it is a very unique and different type of courtroom setting. You would agree?
Definitely.
Okay. And so, having to assimilate a lot of information. We have the parents that have their own viewpoint. We have the department that has their own recommendation and input. And then we have the Guardian ad litem program, and sometimes an attorney ad litem for the child. But I will tell you, and I can speak about Brevard County, and I'm not saying this just because some of you are in the room, but I appreciate and love your reports. You're very thorough and very organized, and the goal is set forth, the date of removal, so we know how long the child has been out of care. And so I pretty much read the Guardian ad litem report first when I'm preparing for court. And the other thing that I truly appreciate is when I see that there's a picture included on the report. Now, not all judges like that, so I'll just put that out there. But I really, truly appreciate that because I don't always see the children. They don't always come to every court hearing. And it's a reminder, I said, to me, that this is the child that we're dealing with today. So I just want to put that out there. I really do appreciate those photographs and the organization that at least the Brevard County folks put into the reports. And I think that there is a format and a model that you all follow. So
Yes.
yes.
Yes,
So-
although, let me just tell you that there are some judges, there are some judges, there are some circuits where the judge really isn't interested in seeing the pictures and hearing about the field trips and things of that nature. And so that's one of the questions we ask the judges to address in the judge's perspective, because I've been in some courts where I'll say, you know, we have a picture of the kids' kindergarten graduation or something. You want to see them? Not really. I don't have time. To me, that's just sick. But, you know, guardians come in a lot of times. I've had guardians come in with pictures that they went to the Christmas party with the kid. I used to be on the board of Friends of Children of Brevard, and I went to the Chuck E. Cheese Christmas party with the kids, and there were lots of pictures and sugar, lots of sugar. But, so, you know, but some judges don't want that. So that was one of the questions we wanted the judge to answer. What is it that you want to hear from us and see from us? Do you want sort of the touchy-feely side of things, or do you want, like your reports are supposed to say, just the facts, ma'am?
On that same note, you know, one of the things that I would stress to the volunteers is, as she said, stick to the facts. I mean, you know, emotions obviously play a big part in our cases. But when I start going down the path and I start hearing, you know, even the parents, whatever party, going down the path of, well, and I heard from so-and-so that told me such and such, and so it's really not, it's like triple hearsay at that point. In other words, unless you actually know about something, it's better left to the person that actually has the information. You know, that sometimes can happen, and, you know, again, not just the volunteers, but some of the parents, they, you know, want to say that something happened, and everybody has a different version of what happened. Of course, there's this version, that version, and then the truth, right? But, you know, just to keep it to what has been observed, how many sessions, for example. I know, for example, I had one guardian and London volunteer that did an excellent job with putting together a chart of the dates that and the weeks that were available for visitation for the parent, and whether they appeared or they didn't appear, and if they came for the visit, they were only there for 2 hours versus the 4 hours, and they did a whole analysis of, for however many hours of visitation that this parent had the opportunity to avail themselves of, and the last time since we were here before the court, and they only attended this many hours. They attended 15% of the time that they had with their child. That was compelling. And I'm not asking you all to do all these statistical analyses, I'm just letting you know that that's compelling information based on observations and based on the fact that these visits were, you know, recorded, and those are the times that were there. So that type of information is helpful. I mean, perhaps I might be a judge that will get into the pictures of the Chuck E. Cheese party more than other judges. But, you know, even seeing the kids' report cards, that's an indicator in and of itself. If you see that the children, before they were removed from the home, that were not doing well, you know, failing grades, or even C's or D's, and now they're getting A's and B's. I love to congratulate a child on their grades. Love to tell them they're doing a great job. So those are the things that I enjoy hearing about. And of course, that shows that their environment somewhat created their poor performance in school. And we need to look at those things and whether the parents are, in fact, remedying the issues, whether it be drug use, domestic violence, physical abuse, whatever those issues are. So all of that really is pertinent information. And I know you can't present everything at every hearing because we're very limited. We only have so much time for every hearing. You have to have hearings once every 6 months on every case. And so try to stick to the highlights of what you think supports your recommendation. So you come into court with a recommendation, whether it be as to the goal, whether the goal should change, whether the placement should continue, or if there's concerns with the placement. So, you know, highlight those recommendations and what supports those recommendations. And that's what I find to be most helpful. But again, I do read the Guardian Ad Litem report first because it gives me the most information, and then I go on to the judicial review report. So, but don't tell everybody else I said that. Although this is being recorded.
Stepping back.
No, truly, I mean, you all are a valuable source of information. So again, there's no affiliation. You don't, you know, you're not aligning yourselves with any of the parties, and you're there to speak on behalf of the child.
And I love hearing Judge McKibben say this, because this is what I said during my presentation, right? That I've heard from a lot of judges that they read your reports first, and it's true. So see, and also that you have no agenda, that you're there for one thing, and that's best interest of the kids. So now you've heard it from our audience, right? Because the judge is our audience. The child is our focus, but the judge has to be our audience once we're in the courtroom. And so Judge, do you have any constructive criticism just generally about what we could maybe do better as a program? You said, you know, you like our reports and specifically statistical analysis. Is there something you think we could be doing better just generally?
I guess the one thing that comes to mind, and this kind of plays into what I said earlier about, you know, sticking to the facts, sticking to information that you may know rather than hearing it from third hand. But, you know, when the parents start arguing, the guardian ad litem doesn't like me. When they start saying, well, the guardian ad litem, they're looking at nothing but termination of criminal rights and they're not interested in reunification. I just would suggest that you all be very mindful of that perception. And I'm not saying that's true, that the parents, whether they say it or not, that you are in fact against them or opposed to them. Because I know that a lot of the guardian ad litem volunteers don't speak to the parents for whatever reasons, and that's, you know, a choice that you all make in conjunction with your case managers and your attorneys and such. But to keep your perspective as objective as possible, to give the parents and or other parties the lack of ability to say that they're biased in my case and they don't like me and they're against me and they're not going to help me get to reunification or whatever it is that they're trying to do. And I would say that that's probably the one thing, just to keep that always on the forefront, that you're just being as objective as possible. Because again, that will lead to some of the other parties saying that perhaps you do have an agenda, if you will. I think for the most part though, everybody is great about sticking to what they observe and what they know about a case, having spoken to the child. I know hearsay, out-of-court statements are admissible, and I can consider those during our regular court hearings. Maybe not so much during a trial or an evidentiary hearing, but you know, it's something that obviously if you've heard the child make a statement that you think is relevant and the court needs to hear it, then it needs to be said. But again, keeping as objective and open-mindedness as much as possible when assessing and making recommendations.
Okay. And so how would this, you know, how would it help you if, for instance, we were to come in and say, you would say, well, what's your recommendation? The department's asking to change the goal to adoption. What is the guardian's position? And we say, we agree, and you say, why? And we say, because mom's crazy.
What would I say to that? Is that helpful? No, probably not. And the mother will probably end up having to be excused from the courtroom because she gets upset. Again, that kind of goes to the same issue. I mean, to be able to support your recommendations when I ask that question, because the department says concurrent goal of reunification and adoption. Guardian ad litem program says goal of adoption. Well, okay, so can you tell me why you're asking for that goal of adoption versus the concurrent goal or otherwise? So having again the basis to support your recommendation. Saying mom is crazy. Well, tell me why. Instead of saying mom is crazy, well, we're still concerned about the mother's mental health issues. She's not attended her individual counseling sessions. She had an opportunity to attend 10 sessions since we were last here, and she's only been to however many. But all of those things would play into showing that perhaps mother's mental health issues are still in question, as opposed to mother is crazy.
So what you've observed and what you've heard, right?
Yes. Yes. Observations and what you've heard. Yes.
Very good. Is there anything that we do generally? And Judge McKibben is in Brevard County, but she's known Vern for a long time. She's known me for a long time. She's known Ellen for a long time. So she has a really she's been involved in the Dependency Court Improvement Project, so she has a really very global perspective. So that's why I'm asking her more globally
Anything that the program does exceptionally well, something that you think the program has done very well, and you've been doing this for 21 years, child welfare. So anything, do you see any change in the 21 years in any way?
Well, certainly the number of volunteers have increased, and that's a great thing. I know in Brevard County, I went to a luncheon a couple months ago, recognizing the volunteers and thanking them, and went into this huge ballroom. And you know, I don't know the numbers exactly, and walking in and seeing the number of volunteers was gratifying to know that you all are actually volunteering your time to advocate for a child. I think that, you know, when I was with the department in the past, and those numbers we've, through the training and the marketing and the recruitment, that you all have increased the numbers. And I do know that we've had some volunteers in our county that have, in fact, she got an award the other day. She's been serving as a guardian ad litem volunteer for 20 years. That's pretty amazing.
Yep. Very good.
And quite frankly, I made the comment after they presented her with an award, and I said, you're pretty much in court every day, you know, along with the department attorneys and the parents attorneys and the guardian ad litem program attorneys. She's almost there every day, literally every day. And that's a huge commitment. But the other thing that I would say is the level of seeking relief from the court has improved. In other words, Guardian ad litem program has filed their own petitions, rather than wait for another party to file a petition for termination of parental rights, for example. Guardian ad litem program has filed the motion to try to get the relief, whether, you know, a vacation that perhaps didn't get approved by the court previously, allow the child to go on vacation with the foster parents, or allowing the surgery. So sometimes, you know, and I'm certainly not saying anything negative about the department. Everyone is pretty much overwhelmed. Unfortunately, we have too many children that have been removed, that are in the judicial court system. I mean, I was in court till 6:45 last night. We had 50 cases on the docket, plus our shelter. So we're overloaded. And so I'm not knocking the department, but sometimes they don't always get around. And so I've seen an increase in the Guardian ad litem program actually going forward and advocating and filing the motions and petitions, maybe even a motion to suspend visitation or to modify visitation from unsupervised to supervised. So I see a lot more involvement from that perspective.
That's good to know. And I agree, and I'm not a department basher either, but sometimes we have a different perspective, right? There's something that we want, and you know what I love about this job is I get to go in and just say, Judge, I want you to do this because it's in the best interest of the child. And I'm an attorney, so I like to talk about the statute every once in a while if I can, or case law, but sometimes the judge will say, what's your authority for that? Because judges like to ask that question, it's their job. What's your legal authority for that? I don't have one. It's just the best interest of the kid. So we can do that. We can go in and ask the court to do things, and that's what I love about this particular position that I have. And the department can't, they're a little bit hamstrung by policy and procedure, and everybody's looking at the department, right? I mean, they're probably the most regulated agency in the history of the world. So we have a little bit more flexibility there, and it's good to be able, sometimes the case manager comes to you guys, right? And they say, this is what I want to happen, but CLS won't do it. Can you guys do it? Sure, we can do it. So I appreciate you saying that.
Right, and I'm not saying that the department's not doing their job.
Right.
They just, you know, sometimes they may not even agree with the relief that the Guardian ad litem program is seeking. They may not agree that the mother's visitation needs to be modified. So, you know, if we had everyone in agreement on all cases, my job would be over. I'd just sign off on orders all day. But that's not how the system works. And so, you know, we're all, again, overloaded, and again, that's the beauty of you all being volunteers, giving your time for a child that needs a voice. And so, you know, we all have different roles in the courtroom and different, perhaps, ideas and outcomes as to what should happen for a particular child. But for the most part, I really also appreciate how everyone works together, because it does take a team. You know, if we didn't work together as a team, we would probably be in court until 8 or 9 o'clock at night instead. But, you know, there are some things that everyone can agree on and say, yes, we're ready to move towards reunification. So that's another valuable piece to keep in mind.
So open up for questions
Sure.
or comments. So, and just, so yeah, I'm sure everybody gets this, but don't ask about a specific case. Judge McKibben can't answer those questions. And then you go back to your judge and say, well, Judge McKibben said, you're wrong. So, but please feel free to ask the judge questions you have about dependency, you know, generally, or comments you have, anything you'd like to share with the group, and I'll bring the microphone to you.
Oh, we have a gentleman over here.
Are children in the court?
Yes.
You want the children?
What is my thought about that?
Yes.
Okay. The question is, children in the court. First and foremost,
In Brevard County, at least, we have all children come to the shelter hearing, unless, of course, there's an issue, like we had a child yesterday that had been Baker Acted. So obviously the child's not available to come to court. But all children come to the initial court hearing, sometimes newborns right out of the hospital. And after that, obviously the statute and the rules talk about unless the child should be excused for good cause. I enjoy seeing the children in court personally, because let's face it, that's why we're there. We're there to address the children and meet their needs, protect them. We obviously don't have them come to every single court hearing, and you know, some that are nonverbal that wouldn't be able to provide input to the court, it's probably a little bit less important. But I always enjoy seeing the children in court, and in Brevard we have what I call our treasure basket, and we have little stuffed animals and little goodies in the basket, and every time a child comes to court, we let them pick something out to take home with them. And if there is a particular child that I have a concern about, I will order them specifically to come to the next court date, and especially our teenagers, our teen population, because, you know, let's face it, if they're not going to be able to be reunified, they have to be given some skills so that when they're 18, they can be independent, or sometimes involved in the extended foster care program, but they need to be given a little bit more hands-on with, here's how you can be a productive adult. And so sometimes when we have the 17-year-old reviews, for example, if they're not there, I might continue it so that they can make sure that that child is there. So, but I like to have the children in court. I don't mandate that they come to every court hearing, and generally will excuse them from further court proceedings unless they want to come or I feel that there's a need for them to come. But, you know, the statute and the rules allow for them to come. So it's really, you know, their choice. And in the instances, like I said, where I want them to be there, because I'd like to address things with them personally and get them on the right track to the extent that we can.
When Judge McKibben and I used to, when we first started out doing, when I first started out doing this, we didn't see the kids. They didn't bring them to court back in the early 1800s.
Wait, how old are you?
I'm not saying. In the mid-90s, right, 96, we were still sort of HRS then. And so we did like the Christmas party and Club Civ and whatever we could to actually get to meet the kids and say hello to them. You're in court fighting for them, doing a termination of parental rights or, you know, whatever, fighting for this particular child you've never even met before. So I was kind of glad when the legislature decided to say, hey, kids need to be in court unless the judge says otherwise. And, you know, because at first they were saying just to encourage the kid to come to court, right? And again, nothing against case managers, but I can guess that conversation went something like, do you really want to go to court? You know you're going to sit for 4 hours before your hearing takes place. You'll get 2 minutes with the judge. So I don't think we were really probably encouraging as a system, encouraging the kids to come to court like they are now. So I'm glad that, how do you guys feel about it? You think it's good to have the kids in court?
Sometimes.
Depends on the age. I think in general, yes.
Okay.
I do worry about how much time kids are missing school.
Right.
Yes.
Or not just court, but everything else.
Right.
Yes.
And that's a great point. And one other thing to more fully answer the question, so, you know, the children that we have that are in facilities, treatment facilities, whether it be they're in the Department of Juvenile Justice facility or in a mental health residential type treatment facility, to the extent that they are able to participate, you know, if it's safe for them to do so and their treatment team approves, then we'll also get them on the telephone. So, you know, try to include them as much as possible. But you're right, because if we're mindful that we can't pull children out of school, or we shouldn't pull them out of school, we would probably start court at 3 o'clock and work until about 10, but that's not gonna work. But there are some cases where I'll say, you know, is the afternoon better? And we'll try to work around that. You know, like especially when we have the older population that we're trying to help them and get to their independence, and it's important that they're in court to, okay, let's schedule this for 3:30 or 4, so that they can actually be there and not miss school.
And
Go ahead. Yes.
Yeah, I'm just wondering if, you said you had a bunch of stories, and I'm sure some of them have to do with guardians. You're too kind to say otherwise, but I'm wondering, like, have you ever been in court and caught yourself thinking, I wish the guardian hadn't said that, or I wish the guardian hadn't done that? Are there any, like, no-nos, like big no-nos, you know, that's in your mind that we should try to avoid or could learn from?
Well, there were, for me, I was the guardian attorney briefly in 2005 and 2006 for about 7 months, and then I left, but I came back. And I was in court, and I loved working with the volunteers. You know, such great people that give freely of their time, like you guys. I mean, they're just awesome, the work you do. Well, I had staffed the case with my volunteer before the judicial review. I had read a report. We're standing in court. She wanted TPR. It had been like 2 years. Kids are still in care, and she wanted to terminate parental rights. I said, I agree with you. We should absolutely do that. So we're in court, and we said, Judge, can you please order the department to staff this case for termination of parental rights? I don't know what's going on here. And she said all the reasons she wanted that to happen. And the judge said, Department, staff this case for TPR. Yay. We're good. So he says, anybody have anything else to say? And the volunteer said, yeah, I think the parents should get some unsupervised visitation. They're doing great. I don't know. I don't think she had ever said to me before. You know? So I was a little confused by that, and I said, no, I think we're good, Judge. That's all we got to say. That was very specific, but one thing I would say, don't say in court unless you need it, is substantial compliance. If the parent has remedied the situation that led to removal and they can get their kids back, say it. But substantial compliance is a defined term. So if you're saying that, putting it in a report or saying it on the record, what you're saying is the kids can go home. So just be careful of that particular term. I don't know if the judge has other things she would like to share.
Well, I recognize that, I mean, some of you may be licensed attorneys, but most of you probably are not. You're volunteers. You have various backgrounds and various careers. So the legal terminology is an interesting piece, because I see this not only sometimes with the guardian ad litem program and the reports, because you all don't necessarily know all the legal terms per se. Hopefully the attorneys are catching that before the reports are filed. But I see that also sometimes with the case managers' summary reports. They'll say terminate jurisdiction, but yet we're closing out to permanent guardianship, and the law says I have to maintain jurisdiction because in the future, if this case comes back, I have to have authority to hear the case. So I see that there's some folks that don't always understand all the legal part of it. And to your point again, to answer, you know, the concerns about what I see or what I've seen, I will try my best to allow everyone to have an opportunity to be heard. When you have, you know, 5, 6 parties and you're having to let everyone be heard, 2 parents, department, guardian ad litem program, attorneys ad litem, you know, again, try to assimilate all the information, but I will give everybody an opportunity to be heard. But sometimes if we're going far afield of the issues, I will somewhat cut that off and say, I don't need to hear any more about that issue. And so sometimes that'll prevent some of these things that you're talking about where statements are made and they shouldn't have been made. You know, sometimes parents will blurt out things that their attorneys are like, you know, shuddering at the thought of them saying what they said. But again, it's dependency, you're involving children, you're involving families, and emotions run high many times. And so it is the one division that, quite frankly, you probably have the most security issues, more so than in a criminal courtroom. Truly. You know, you've got lots of, I have 2 deputies, whereas when I was in family and when I was in the criminal, I had 1 deputy. So, you know, 1 court deputy first, you know, so it is obviously, we're talking about people's lives. We're talking about people's children and their rights to custody and whether their rights are going to be terminated, and mental health issues, and you never know when someone is going to have a meltdown, a breakdown. I had a woman the other day in court that the allegations were domestic violence, and I saw her standing at the podium, and it was a shelter removal. The father was in jail, not on that, but on something else, but he wasn't there, but the mother was visibly shaking. And I saw her face, she was turning white. And I thought, she's going down if I don't let her sit down, she's gonna pass out. So, I mean, there's just so many things that can happen in the courtroom, and emotions are high. And so trying to keep people from perhaps saying things that they otherwise wouldn't necessarily want or need to say. So we try to prevent that if we can. Yes, ma'am.
Substantial compliance. DCF, I disagreed with the DCF on one of my cases, but that term was used. And I said, she said, okay, they have a roof over their head, they have food, they have electric, and I'm thinking, yeah, he has bug bites and he's got, you know, all this crap. What is the judge, what is it really that is substantial about it? You know, because I thought it was crap.
Okay, well, as Ms. Swartz said, substantial compliance is specifically defined in the statute.
Where do you
It's
find it?
Chapter 39 in the Rules of Procedure.
Okay.
So you can talk to your attorney.
It's in 39.01, the definitions. Yes.
39.
0.01, the definitions, and then they're alphabetical, so it's 40-something on that. 50-something.
Substantial compliance.
Yes.
And it basically means to the extent that the parents have remedied the reasons for removal. So if the issue is domestic violence, just because they've attended a course and they get a certificate, for those that were in the substance abuse program earlier, doesn't mean they've necessarily remedied the issue if they continue to get arrested for battery and domestic violence. So, you know, just because you have a piece of paper saying, oh, I went to a parenting class, you know, that does not necessarily mean substantial compliance. It's showing that you're no longer going to present a risk to your child and you've remedied the risk.
But when you're looking at DCF's recommendation and when you're looking at the guardian's recommendation, and the manager is going, well, I really kind of agree with you, but the echelon says this case has been here long enough. We need to get rid of this case. It's been 2 years. Who carries more weight with the judge?
It's not really a matter of weight. I mean, because again, you all are parties on equal footing to every other party. It's just a matter of trying to listen to all of the information and evidence and making a decision that I hopefully will make in the best interest of the child. And it's not that, oh, today I'm going to side with the Guardian Ad Litem program, and tomorrow I'm going to side with the Department of Children and Families. That's not how it works. As a judge, you just have to consider all of the evidence, facts, the best that you can, and make the best decision that you can.
And Judge, what goes into your consideration? What are the factors that you consider as far as, like, you have a contested hearing with people testifying and presenting evidence? What factors into your considerations?
Well, I mean, it depends on what the issue is ultimately and what I have to decide, but, you know, if this is a full evidentiary hearing or a trial for that matter, and witnesses are called, I have to not only listen to what they have to say, but I have to determine their credibility, observe their demeanor. You know, I may have a witness that I don't believe a word that they're saying, and it's totally and completely contradictory to another witness, and so I have to weigh all of that. And again, I know we have judicial reviews where they're really not full evidentiary hearings. I mean, hearsay is presented all, during the whole hearing. But I try to do my best to consider what are the facts showing me? What are the witnesses showing me to show that this child will be safe if returned home, or whatever the issue is for visitation. So I'm not sure if I'm, completely answering the question, but weighing the credibility and
Demeanor.
and even, sometimes attitude, quite frankly. Sometimes, parties will get angry. And, there's a thought process in terms of when a parent, or it's generally the parents, unfortunately, that this will happen to, that they get upset and they will start yelling or get, angry or whatever. And so, you have to control the courtroom. It's my courtroom ultimately. I have to make sure that we are following procedure and decorum. But sometimes the parents, despite what their attorneys may say, will start just going and going and going. And sometimes that's the evidence to say that they're still having an anger management problem. So to let them kind of say some of the things that they might want to say otherwise, because otherwise I could simply cut them off and say, "Sir, you need to stop talking." I mean, there's a balance, but all of those things and assimilating all of that information, and that's what I have to do, and hopefully make the best decision.
And one thing I think we're safe in saying is the judge has never made a decision based on something she didn't hear, right? I mean, I don't think I've ever, and I said this in the earlier session I did, I've never heard a judge say, "Boy, I made a mistake on that case because I had too much information." So
Usually I don't have enough information.
right,
quite
your
frankly.
information is critical. And the judge can't make a determination based on something that you haven't told her or him. So it's critical that your information comes out. And your credibility and demeanor matters, and your attitude. I mean, it does. And that's not a problem with most of you guys. And like the judge said, the parents, I used to represent parents, and I would tell them, "Shut up. Stop talking, chucking yourself right into this TPR." So,
Yeah, I mean, and sometimes, presentation too. I had a parent in court the other day, and literally, in my mind, he had made 180-degree difference. I mean, he looked completely different. He obviously had completed his class as domestic violence. The parents were back together. There was, no reports of any violence, and it's amazing sometimes just physical appearance alone. And of course, that plays into parents that are under the influence. When they're drug screened, and I have a drug screen that says they're positive for cocaine, and they're standing right in front of me, and some of the things that they may say may not be as credible then as, other information that's being presented. So all of that factors in. And so it's not a matter of which is, which piece of evidence, if you will, do I weigh more heavily. It's just a matter of putting it all together and, again, making the best decision that I can.
Does the time element weigh on your judgment if they've been in the Guardian program for X amount of time? Are you of the opinion that it needs to be closed if there's sufficient compliance? Say if it's been going on for 2 years. In your mind, are you thinking this needs to be resolved if a substantial compliance has been reached? Does that weigh more on you as far as?
Time considerations always have to factor into the decisions. Because if you're talking a child that's only been out of the home for 3 months, the parents have only had a brief opportunity to work on their case plan versus a child that's been out of the home for 2 years. How many, more months do we wait for permanency? We should have reached permanency before then. So time factors and considerations always have to be thought through. So I may be inclined to change a goal in a case where we're at 11 months versus obviously 6 months. So all of that has to factor in, and in fact, the guardian ad litem program, the child is the one that has the rights to the timeframes.
Yep.
When I ask any objection to a continuance, ultimately the child has the right to, and through the advocate has the right to say, we object to a continuance. This is only going to delay the case even more.
okay, anything?
I just have a question. What about if the judge ruled that the children, can be reunited with their mother and you said, you know, you didn't think it was a good idea, but they were, is there any recourse after that when you know that 3 months from now, those children are going to be back in the system?
Yes, first you say, Judge, you're wrong. No, I'm just kidding.
And then you get your crystal ball.
Yes, there is recourse. We can appeal. We can appeal a court's decision. Now, in order to do that, we have to have presented our evidence in a proper format, not just wish we would have said what we should have said. So we present the court with everything. And like Judge McKibben said, jokingly of course, but no court has a crystal ball. The courts make the best decision they can on the information given to them. Anything else you want to?
Yeah, I mean, you know, if seemingly a parent appears to be doing well and has done everything that we've asked them to do, I can't predict if 2 months later they're going to relapse. I mean, all we can do is, you know, support what's been presented and help them, hopefully give them the services post-reunification, or whatever the case may be. And, you know, again, none of us has the absolute ability to predict what might happen, and again, supporting them through that process and making recommendations as needed if something should change. You know, if mother's testing positive again, come back before the court then and let's readdress it, and perhaps the children need to be placed elsewhere, even temporarily.
And we have a great appellate team. We really do. So we file appeals all the time. And we don't always win them, but it doesn't mean we're not going to try. So if it's our position that the court, having heard everything, made the incorrect decision under the law, then we'll appeal it. Not just because we didn't like we disagreed with what the judge did. Because we're going to, at least one person is going to disagree with the judge when we leave there, right? Either the department or us or one of the 9 parents' attorneys.
Any other questions?
They can appeal too.
They can appeal too, yes.
I mean, pretty
Yes.
much everyone
There
has a
must
right
be
to appeal.
appeals going on all the time.
I mean, there are
Yes.
some legal differences as to when you can appeal and a non-final order and all that stuff, but
Yes.
that's a whole other issue, a whole other seminar topic.
Yes.
Yes.
I just, in an earlier session, there was someone who asked a question about, we're on this paperless system now, and there was someone who asked a question of, when there's a trial, you know, usually you might be able to bring your paper notes, but could you bring your laptop there? And so I wasn't sure we really answered that question.
I agree
what
with
the
you.
judge would think.
Yeah, on the witness stand, the question was, especially this circuit has gone paperless. So, yes, just leave here. And I said, some judges won't even let you take paper, which you pointed out also.
Yes, Judge Sheck would not let me take anything.
Right. So are we at the point where a witness can have their laptop when they're testifying from the witness stand?
I'm not sure that I've ever had anyone bring a laptop up, but this question was actually posed to me before we started. And from my perspective, I never have a problem with someone bringing up their notes with a couple of caveats. First of all, you can't be reading from your notes. And generally speaking, if you walk up there with notes, the other attorneys are going to ask, do we have those notes? Which means basically those notes should have been given and disclosed as part of the discovery, part of the evidence in the case. So they're going to ask that question, and then as soon as you start to look at those notes, they're going to say, objection. They're looking at their notes, they should be simply testifying from their memory. Now there is, and Ms. Swartz, you can jump in, but refreshing recollection. If you can't recall, is there something that can refresh your recollection? Yes, my notes, so you could potentially look at your notes, but again, that creates a question or a potential issue that if you haven't provided those notes, that you may have a discovery violation and those issues. But I've never actually had somebody come up with an actual laptop, but I recognize that as our technology improves, I mean, we're paperless in Brevard, even though I usually have some hard copy reports. I'm supposed to rely on the electronic record. Things may change in the future where people, instead of bringing up their manila file folder, they're actually bringing up a laptop. So, but again, you're supposed to be testifying from memory. And if you can't remember, like let's say it's a date of a visitation, then you are authorized with permission to refresh your recollection if the proper questions are asked. So, but some judges may see it differently.
I would be playing solitaire on my laptop.
So are there any other questions? Oh, sorry, did you want to say something else
No,
about
just,
that?
I don't think we have a good answer to that. I think it's gonna be court by court, hearing by hearing, because maybe you can have it for one hearing but not another. I know last time I was in the federal courthouse, you can even take your phone with you.
Like on that, even though we're paperless, what I personally do is I write up my report in Word and save it on my, so I have it all in Word, and then I put it on the website instead. So you don't, even though we're paperless for us, you still have your own records that if you want, you can print out and you
Right.
have your own notes.
That's
kind
great,
of like
yeah.
a side way to get around that.
Because I would be uncomfortable without my notes with me. Anything else?
Any other questions? Well, again, thank you for what you do. I appreciate your volunteering and being voices for the children in our dependency system, and appreciate all of our county folks as well. Thank you.